Доброго дня. До нас доєднається наш колега з Естонії. Я рада вітати і дуже вдячна журналістам, які готові слухати, готові писати, пояснювати своїм читачам всі теми, які ми пропонуємо їм до обговорення. Дякую шановним спікерам за готовність знову ж таки пояснювати і доносити через шановних посередників інформацію до кінцевого споживача. Я зі свого боку маю сказати, що Український кризовий медіа-центр кілька разів
Our Ukrainian media center has done some work in promoting Euro-Atlantic integration, but it appeared that nowadays this is much less popular with both the media and the public, and our analysis has shown that one of the reasons of this drop in interest is communication style of the representatives of the authorities who mostly communicate their messages to the public via this prism of the association agreement between Ukraine and the European Union. Therefore, we switched to more narrowed topics, like, for example, environmental aspects, like, for example, the utilization, the processing of the urban waste, for example, some economic aspects. Today, what we propose is a panel discussion with the participation of an Estonian representative who would give his, so to say, keynote remarks on the Estonian practices and experiences in the realm of protection of consumer rights. So we wanted to focus our discussion on the new developments in Ukraine, in this area, and the activities of the NGOs, and also discuss such a topic as the synergies of the NGOs and businesses in protecting consumer rights, as a lot of members of the public perceive business interests as sometimes, on the different side of the barricade, on the opposite side of a barricade, vis-à-vis the interests of the public. Therefore, I would like to give the floor to Mr. Ruslan Tkachenko, who is the head of the expert group on cooperation in the on agrarian policy, consumer protection, and technical regulation of the Government Office for the Coordination of European and Euro-Atlantic Integration. I would comply with your advice, and I will not make references to the association agreement in general, but I would rather make references to such aspects as the growing e-commerce, for example, the other aspects of commercial activities that spur, so to say, these debates on consumer rights protection. Therefore, as I represent here the Office of European Integration, I need to point out that we, in our efforts to promote European integration of Ukraine, focus our attention on the protection, on different aspects of related to the protection of consumer rights. What are the practices of the other countries? What could Ukraine borrow from the practices of the EU countries? It's, for example, the settlement of disputes, and it's because this area is interesting because the protection of consumer rights in courts is quite costly and time-consuming. Therefore, it takes a lot of time and energy from the consumers to turn to the lawyers, to go to court, and after we analyzed similar situations in the European Union, we saw that in the majority of countries they have the out-of-court settlement mechanisms, which simplify significantly and speed up the settlement of different disputes between the consumers and the businesses. Usually these out-of-court settlements are practically free of charge to the consumers, to the claimants. And if I'm not mistaken, about 5 years ago, here in Ukraine, there was a platform introduced, electronic platform, which the consumers could use to download, for example, a standard complaint form that can be presented later on to the appropriate government agencies. And that platform rather was not introduced in Ukraine, and Mr. Tkachenko says that he hoped that in Ukraine it could also be possible, and he says that at such a platform, should it be created in Ukraine, the text of association agreement could be published there, and it could also be supplied by some contact details to the experts in the area of consumer rights protection, who could advise the public, give different advices and counsel the public on different aspects of conflict settlement with of the consumers with the businesses. So that, in our view, is the main venue, so to say, could be the main venue of better settlement of the disputes between the consumers and the businesses. We also looked at an opportunity to involve some business associations, like professional associations or sectoral associations of different businesses. And these associations, their practical activity in terms of, consumer relations, proved in some country members of the EU to be very effective in terms, in as far as they are have usually been interested very much in settling the disputes as soon as possible. And so I think that this experience, this practice could also be used in Ukraine for, in order to better these practices in Ukraine of consumer rights protection. That's my brief, these were my brief remarks. Thank you for your remarks. And now, after we have heard two representative of the Office of Euro-Atlantic integration, of the Government Office for Coordination of European and Euro-Atlantic Integration. And now we are going to listen to the representative of the Department of Enterprise Development and Regulatory Policy of the Ministry Ministry of Economic Development and Trade of Ukraine, Mr. Vasylchuk. Mr. Vasylchuk starts by saying that he wants to inform the public on what his ministry has been doing in the realm of protection of human rights, consumer rights. At the Ministry of Economic Development, we have established a working group, including not only the representatives of the government bodies involved in this work, but also the representatives of different sectors of entrepreneurial activity, of economic activity in Ukraine. And what our government office colleague has already mentioned is valid in our work too. For example, this sphere of dispute settlement. We have contributed a lot to improving the situation here. For example, if the Consumer Rights Protection Agency receives a complaint, it works practically free of charge to protect the interest of the consumer. While through the courts, it could even initially be the initial expenditure for any claimant could be not less than 400 or even 600 hryvnias. Therefore, it was our aim to develop better regulatory environment for the consumer rights protection and to define better both the consumer rights and the responsibilities of the businesses in this area. Another area of our efforts was to develop certain mechanisms improving communications with businesses in terms of or as far as the dispute settlement is concerned. So now, with the support of our government office and our European Union partners, we have started working also in the area of electronic commerce, and we also started a campaign on raising awareness of the consumer rights among the public. We even have developed, ordered the development of a number of mobile phone applications for that. And as today we have around 70 technical regulations and technological regulations establishing different technological standards for the safety of products. It's quite difficult for any given consumer to sort things out for him or herself and understand clearly the peculiarities of these regulations, let alone all the information that the technological information they contain. Therefore, we hope that these our efforts would simplify this raising of awareness and better understanding of consumer rights. And we hope that there will be also the better channel of communication between businesses and consumers. And for example, if we speak about the safety of products, we should take into account that it's not only related to the consumer rights protection, but also to the oversight of the market activities of many enterprises and commercial establishments. Therefore, we in one of our electronic application, or computer application, we have put there a number of options enabling better communication among the businesses and between the businesses and the authorities. Also, we have developed an app that could be used by the inspectors of the government regulatory and oversight bodies, monitoring and controlling the issues of safety of the products, so that their inspections could be done in an organized and a well-structured manner without any possibility of any abuse on the part of the inspectors and controlling bodies. So I hope that my colleagues would elaborate on that, but I would like to say that another important part of our work was the development of a list of goods and services that were to be subjected to oversight by the controlling bodies of the governments. And I also support the idea of revising some of the annexes to the association agreement, and I am ready to answer your questions on all these issues or any other issues that you might be interested in. Thank you. I would like now to turn the floor over to Mr. Oleg Kobelkov, who is the specialist of the Department of Consumer Protection of the State Service of Ukraine for Food Safety and Consumer Protection. Mr. Kobelkov says that he is going to guide himself in his brief presentation by the documents and regulations of the government of Ukraine, and I'm also going to dwell, he says, on the issue of cooperation of the government and the businesses in consumer right protections. First of all, the work of the government agencies which are involved in the consumer right protections, they have been under close scrutiny by the non-governmental organizations, and they helped, to straighten out some discrepancies, some conflicting situations, some disputes that have existed and probably would exist in the future. But Mr. Kobelkov proceeds, the situation radically changed in 2017 when there were two acts adopted, or rather statutory instruments. One was the regulation by the Cabinet of Ministers in this area of consumer rights protection, and the technological, so to say, guidelines for the implementation of that document. So let me now inform you about the priorities that were set by the government for 2018 and how they were implemented last year. So the efforts of the Ministry of Economy were already mentioned, and I would only like to add that the Ministry of Economy and Economic Development continues working hard on the new version of the law on protection of consumer rights, and this law, we hope, could include both our practices and experiences and of the other governmental bodies. We hope that this would be a very good instrument that could regulate this area better and bring the consumer rights protection to a new, qualitatively new level. Our service of safety, food safety and consumer protection conducted 175 meetings and hearings with the businesses, informing them about the need and various aspects of compliance with the norms and provisions of the relative or respective regulations and acts. We also worked with the NGOs, actively asking them to help us in establishing the facts of violations. We also conducted 23 roundtables and meetings also on the practical ways of resolving the problems. So if the first group of events that I mentioned was mostly informative, the other one was dedicated to practical, to the ways of practical implementation of the existing laws and regulations. So in this context of the development of the new version of the Act on Human Rights Protection, I hope that the experience and the practices of the last 15 years could be summarized and put into this new law. In order to popularize the consumer rights protection movement, so to say, we have worked actively with the children even. We, for example, recently conducted a special exhibition for the children dedicated to consumer rights protection. Also, implementing this plan implementation plan that I mentioned before, we also, using the experience of some other European countries, have established the consultation centers for the public, so that the public could be informed, better informed, and get practical advice and counseling from these centers for consumer rights protection. I hope that improves really our cooperation and raises the efficiency of the work and our cooperation with the non-governmental organizations. Also, as far as our cooperation with the local authorities is concerned, our service, supported by the Ministry of Economy, is helping the local authorities to train their specialists in consumer rights protection. So we are trying to aid local administrations in training their own specialists. Another important area of our cooperation with the NGOs was the creation at our website of the Service of Food Safety and Consumer Protection, a dedicated, part at our website. We published there the invitation to the NGOs to share their information, their findings with us. And more and more information started to be published on that website. For example, the expert examination of the advertisement or different advertisements. It was done, this research was done by the Association of Marketing Specialists and Marketing Companies of Ukraine. We have also increased the number of the amount of information dedicated to the protection of human rights and awareness raising among the public. We have not organized any campaigns yet because of the lack of funds, but still we provided as much as we could the assistance to the NGOs. We consulted them on all those issues so that they could publish or popularize in different other ways this information on the protection of consumer rights. Now about the relations between businesses and the government bodies in the realm of consumer rights protection. I would say unequivocally that cooperation between businesses and the government is not only needed, it is inevitable. We are all interested and we have all been discussing the e-commerce issue. And there is a problem there. If we take our work, our service, about 42% of claims and complaints from the consumers resolve in the interests of the consumers. But as far as the so-called electronic stores or electronic shops disputes with them, between them and the consumers are concerned, it's 5 to 10% of the cases that are resolved to the benefit of a consumer. Sometimes it's even a problem to find the exact location of an e-commerce establishment. And the only provision in the existing law on consumer rights protection is the provision that regulates the breaches of contract between the consumers and the commercial establishments. And it's not sufficient because a lot of information is lacking. The e-commerce establishments, if they are fake, they do not even provide their contact details or correct contact details. And it's been for 15 years now that we have been trying to explain it to the businesses that it's not our whim, so to say, to implement the requirements, the necessary requirements in terms of e-commerce standards. And after 15 years, a bill number 5564 appeared, and that bill provoked practically, and as it provided an option of taking down the fake websites of the fake electronic commerce establishments. It caused the outburst, so to say, of protests among Ukrainian commercialists. But if we take into account that dozens of thousands of consumers buy, for example, the long-term consumer goods like some sophisticated electric appliances or electronic appliances, and they appear to be defective, and the consumers have no way to substitute them or replace them or to get any compensation, that situation cannot continue longer. I must say that the same lack of proper legislative and regulatory provisions is typical for the advertisement business and marketing information. Therefore, I support this new bill, and my advice is that the next time when we want to improve the situation in terms of regulation of some commercial activities, we should not wait for 15 years, or rather Ukrainian businesses should not wait for 15 years, but put their things in order by themselves and structure their activities so that there could be less disputes and conflicts with the consumers. And as this new mechanism, these provisions of this new bill that is now under review could increase the number of court proceedings, there are no alternatives. Something should have been done, and this is the bill that we support, although I certainly agree to a number of critical comments, and as a representative of the Food Safety Service and Consumer Protection Service, I am going to defend this bill. Well, thank you for your remarks, and I hope that we can now hear the comments from the other specialists who might not be your direct colleagues, but who are your colleagues, so to say, in as they work also on the consumer rights protection. For example, today we have Mr. Tsilvick, the Deputy Chairman of the Board of the Union of Consumers of Ukraine. And as last Friday there was the International Day of Consumer Rights Protection, I would start by saying that I've never been, so to say, permanent critic of this system of consumer rights protection in Ukraine. I must say that it's inadequate now. Before the reform that was mentioned, the introduction of that new law of 2017, the inspections were suspended, and in that time the whole new sector of shadow, if not outright illicit economy appeared, and they are out of access, inaccessible to the market oversight bodies. Therefore, in the concept of human rights protection that covers the period until 2020, it says directly, the document says directly,
Ринковий нагляд
that the norms and provisions of the existing laws and regulations are declarative. They cannot be implemented in practice. And today, as we know, the e-commerce, especially in Ukraine, is lacking oversight, as well as the open-air markets and other commercial establishments remain unregulated and not monitored by the government at all. At the same time, we today have more standardization and safety government agencies and bodies than any other European country has. But their work does not bear any positive effect on the safety of products that Ukrainian consumers buy. So we now try to involve more NGOs, for example, on that work or on the new version of the law of the consumer rights protection. There is also a working group on developing the mobile application for this. But again, if we get to the Ministry of Economy, their role is a policy role. The role of the executive body in this realm is the Service for Food Safety and Consumer Protection, and there they are lacking the possibilities to work effectively because of that law of 2017 and the suspension of any market control. What are the prospects? The first one is the so-called fiscalization, and the amendments were introduced 2 years ago, and for example, there was the government decree number 231 that established the need to sell sophisticated electric equipment only with the fiscal receipts, fiscal documents. And that was a wonderful provision, but today, if people buy some electrical goods that are defective, they oftentimes cannot even find or reach the e-commerce, or rather the commercial establishments, and let alone the producers who could replace or substitute those products. As far as the fraud in e-commerce is concerned, I must say that with our efforts, or through our efforts, 3 criminal cases have been initiated pursuing, or rather, pursuing the fake e-commerce establishments. The other important aspect of our work was the amendments to the existing law on consumer rights protection. For example, an amendment was offered to provide 100% compensation to a consumer in case a defective product was sold to him or to her. Although there were some, disputable provisions, like, for example, one of the provisions enabled the consumers to exercise the function of control of the documents of a commercial establishment. It would be, in my view, unproductive, because if you have a consumer who spends money at your store, for example, buys something, and then he is controlling your documents, the provenance of the products, and so on and so forth, a lot of commercialists would not be interested in such forms of control and would probably abandon this type of commerce, or the commerce in these conditions, at all. Another area is the work, the competition among commercial establishments. For example, some stores employ the so-called entrepreneurs as their salespeople. They do not have them on their payroll. They do not pay them salaries, and they cannot compete with the commercial establishments where there are people who are the entrepreneurs and are not paid salaries. Some of such stores even sell smuggled goods. And for me, it was a revelation that smuggling and commerce in smuggled goods is not considered punishable under the criminal code of Ukraine. There are also fines that could be taken for trade in smuggled goods. Therefore, today, the legislation, the existing laws in Ukraine are declarative. I agree with that. And it's good that we have the journalists today with us, because I would like to say that our organization, for example, abandoned cooperation with the government bodies as being totally ineffective. We, for example, lodged 13 complaints since January, and they have not been reviewed by the government at all yet.
In February 2018, one of the consumers addressed the court in Obolonsk district of Kiev. First, they reviewed this complaint for the first time this year, and the efficiency of system is really low. In Europe, it is 90 days, and here people cannot protect themselves in courts, and the level of satisfaction of complaints is about 8 or 5%, depending on the sector. So we directed our efforts to cooperation with mass media. When you warn the consumer about the risk, it is more efficient for him not to buy the products or what risks he will face. It's easier than to fight for each consumer separately. And all leading channels have programs for consumers, and the representatives of our organization provide consultations, and these programs are at the top of the ratings. And also, consumer right protection is one of the main tasks now, and this brings the audience, and we understand that if we, for example, want to see, if you want to see changes, we should have this extrajudicial resolution of disputes. This is not only about filing the complaint in the place of selling, but also there is an association now, and in Europe they call it self-regulatory organizations, and they take responsibility for some share of the market. They unite the representatives of the market. They have the security fund. They collect funds from all the participants in order to compensate in case of risks and to compensate the expenses of the consumers. And so there are a system of ombudsman, and here we have one ombudsman on business in Ukraine. He protects business if the consumer rights are not protected. Why don't we have such ombudsman in consumers' rights protection? In the same hall, we had the ombudsman last year who deal with the issues of energy and protection of consumers in the sphere of energy supply. And I asked about sources of financing. So the source of financing is the company at which the consumer complains. So any dispute is at the expense of the provider of services, and the energy market and communal services, these markets are monopolized. So there should be a system that is financed by the providers. These monopolists, companies, should compensate the claims of the consumers. But today we have critical problems, and these issues are not resolved for consumers. And that's why today this is a really acute issue. And there are positive things provided by governmental bodies, but we have a lot of problems, and we should find out how to resolve these problems, and maybe you have some proposals how to do it. Thank you. So this was the voice of the public sector, of the civil sector. Now we are going to listen to business. Sofia, and she's the Director General of the Association Ukrainian Importers of Consumer Electronics, member of the Ukrainian Business Council. Sofia Araslanova. Thank you very much for this invitation, for solidarity and understanding of the situation. I have three messages. The first one about the positive trends that support this not ideal system of protection of customers' rights. Second, real realities, real situation that is really bad. And the third, what is the solution for business and what proposals we have as the representatives of business. All we know, business people and consumers, we know that sellers started to compete with the assortments of products. Then the sellers, they competed, they had some price wars. For example, 3 items at the price of 1 and other techniques. But today there is a world trend when the rent of the capital is replaced by the rent of relations. So this is the new relation between the buyer and seller. So this is systemic business, and business They study clients' experience, the practice of buying, why it is important. This is important because those buyers who are not do not like these products, they do not return to the same buyer. They share their opinion with 8 or 10 of their friends. They will share their negative experience. And McKinsey shows that they will share more negative opinion, not positive ones. That's why sellers, they should study the situation and they should establish proper cooperation with consumers. And this may help temporarily, but when we're speaking about consumers' rights, we should understand the trends. And not all sellers do like this. And what is the situation in the market and the market of electronics and household appliances? Some work in the real sector, in white sector, and they pay taxes, and part of sellers are in the shadows, about 30%. This is the level of the shadow economy. Each third seller is in the shadow and doesn't pay taxes. And my colleagues confirmed that it is impossible to find, to identify. We cannot identify them on sites. They do not show that they are legal entity, and our consumers, they are just in some virtual sphere of buying, and our consumers cannot recognize them. Also, these sellers, they have profit, and this profit, it includes these taxes that they didn't pay or underpaid. So this is bad competitive field for legal business. Real business faces really difficult situation. Can they protect the rights of consumers? They are ready to do this. White business initiates proper changes. We participate in working group to create such a product, an open project together with the Ministry of Trade and Economic Development, and many people support this initiative by their participation and by their example. And we invite others, and all those proactive people with a good civil position, our colleagues, to join us. From the other side, we understand that we should order the situation, because this triangle is not good for anyone. It is not good for seller, customer, or state. For the customer, this is the direct risk. He can buy dangerous product, cannot return the product and implement his or her rights. In case, for example, of buying electronics, and there are no guarantees, no fiscal check, and the customer is not able to protect his rights because he doesn't have the check. And also, it takes a lot of money to resolve such disputes. Also, for business, this lack of competitiveness. There is no proper competition conditions between those who pay taxes and those who don't. So, for the state do not receive the taxes, and the dangerous products are on the market, and also counterfeit products are sold. And
what are the ways of resolving this situation? First of all, we would raise the awareness of the consumers about their rights, inform them better about how to consume and what their rights are with respect to acquisition of different goods. There is an internet portal, Consumer Support it is called, where the information is placed informing the public on consumer rights protection. Next, we support the bill providing for the return for the compensation or reimbursement of the expenses, and we support the idea of a customer becoming sort of an inspector, him or herself, where he can control the commercial establishments and thus be able to resolve positively his or her complaints. In 2018, an interface was launched at the fiscal service, state fiscal service service. It's an option that enables the verification of the receipts and fiscal receipts, as we call them. These are the receipts indicating the data of the commercial establishment. According to the statistics of the State Fiscal Service, in the first 2 months of this service launched, in the first 2 months after that, 13,000 receipts were verified by the consumers. Also, the control on the chain of the price formation for the goods, especially imported goods, should be established so that the risk products should be put under fiscal control at the points of sale. Thank you, Ms. Sofia, and let us ask now Mr. Oleg Zubchinok, the Deputy President of the Oil and Gas Association and the Chairman of the Competition Development Committee and a member of Ukraine's Business Council. We invite him now to speak. Thank you for your invitation. You could see at the screen here our internet address, and you could visit our website. And as I am the last speaker of this presentation part of our event, I would like to say that it's possible for a consumer to protect his or her rights. First of all, he or she needs to fix somehow to register the fact of the acquisition of goods or services. Most companies are quite concerned about their image, and they monitor eagerly the reaction from the customers on the interaction with them. So let me just say why it is important for the systemic business that are represented by our association. I'd say that, for example, in the fuel stations, petrol stations, interaction with the consumers, their commercial operations are always accompanied by the receipts. They always issue the receipts to the customers, and having this receipt, a consumer can make a claim in case he was not provided the services he or she wanted. Our association is interested in, and all the companies, members of our association, they are interested in making, so to say, our business environment healthy, well structured, and therefore we have here a number of provisions that you could see the goals of the activities of our association. I'm not going to read them out loud, but you could read them here on the screen. We are also supportive of empowering the government agencies in their market monitoring efforts and market regulation efforts. Today, the situation in Ukraine is quite serious with regard to the sales of petrol and liquefied gas. I would say that according to our estimates, around 1,500 petrol stations distribute, sell their product with no proper, licensing and regulatory documents. In case something goes wrong when you are serviced at such petrol stations, it's up to the customer. He or she is not well protected in dealing with them. According to our information, last year alone, around 500,000 tons of fuel was sold via such illicit commercial establishments or non-properly registered commercial establishments, and it's about the turnover was around 10 billion hryvnias. For you to understand the scale of these violations, it is such that it causes losses, heavy losses of tax revenues for the national budget. This part of the market is a shadow market, and the state bodies can not always access these shadow commercial establishments. And our association is trying to help in visualizing this problem, so to say, make it more visible. As the consumers, we oftentimes see the information that after their protests, the authorities react by saying that we are dealing with this problem, but soon after you discover that these almost illicit commercial establishments continue operating as if nothing happened. We used the Lithuanian experience here, and we compiled this map with the commercial establishments that are not entirely legal. Such map, it helped the government bodies to control the situation better. For example, in this map, it could be seen that if an establishment was shut down by the authorities, soon after it was reopened and started operating again. How is this map the information from this map is being implemented, so to say? For example, if a governmental body publishes similar information, not an NGO, how could this information be used? Well, there could be a discussion on how whose role is to gather this information, whose role is to publish, and how the reaction, what the reaction of the government should be. But we would probably discuss that after my presentation. I would like to get through with my presentation. The idea is that if such map is filled in, so to say, with the information from the consumers, then this map would be real. It would contain real information. We have already had, for example, in our organization, our association, a few hundred claims and addresses from the consumers. And in a similar map for Ukraine, about 1,200 establishments was already detected. 952 of them continue operating as if nothing happened, although we informed the authorities about them. And we know that for our system to be efficient, we need to monitor these similar establishments, and the information that is in the public domain can be published. This information is entirely open. Again, in many cases, we are not being, the investigative body. We cannot prove 100% the fact that the operation of such business is illicit, but at least we can draw the government's attention to that. Here, for example, we have we can present a number of photographs in which you could see these practically illicit fuel stations, petrol stations. As you can see from the photographs, even the safety standards are not complied with, and it might be dangerous because these are flammable products, and this situation continues because of the lack of control of that shadow segment of the market, because they do not pay taxes. They maintain lower prices for fuel and fuel products. And what we are going to do is to continue to explain to the public the risks of these services of such fuel or petrol stations. Among the features, so to say, of the illicit operation of similar commercial establishment, the first is that, for example, the receipts are not given when you buy petrol from them, or they issue some sort of not real fiscal document. Sometimes you could see that they are located in the vicinity of some, residential housing, even kindergartens sometimes, which is a direct violation of safety standards. So you could inform us about these facts. We pay for the hosting of our website, and we can place the information on this website related to any violations of the rules of commerce in fuel products. If you identified an object like that, at least try to lodge the complaints with the authorities, as many governmental bodies as you can, and then you could also certainly inform us that we will place this information on our map, and that will speed up the whole process of identification of such illicit object by the authorities. Especially if you have any doubts seeing such a illicit petrol station placed or located in the residential area without safety standards at a close distance to the houses or other public premises, and so we invite you to get involved in this work, to gather this information and share it with us. And we hope that through our joint efforts, the number of these illicit commercial establishments would diminish. Thank you all very much. Let us now start our questions and answers session. We tried to represent all the views existing views on the issue of consumer rights protection. We all are consumers of different types of products. Therefore, I think that we managed to present a balanced picture. So you can now ask your questions. TV channel Healthy Ukraine. My name is Stanislav. If I identify, for example, a liquefied gas station distributor in an area which is residential area, are you able to help in shutting down such a commercial establishment? If I write a letter to you, would you be able to help somehow? Let me tell you how how can it be done. It's not about the elimination. We are not that blood-seeking entity. What we do, we usually inform the city administration, the mayor's office, and here in Kiev, the mayor's position was clear. There was a memorandum even signed between our organization and the city council, and they committed themselves in eliminating these illicitly placed commercial establishments. They started disassembling their premises, and in some cases they were entirely shut down. In some places and situations they were relocated to the other areas with proper permissions and so on. We also share our information with the State Fiscal Service, and we could help you in bringing this information to the information you communicate to us to the attention of the Fiscal Service of Ukraine. As we all understand, it's the local authorities' work to monitor and control the commercial activities and different commercial establishments and the validity of their work, their operation. If you have any more questions, I wanted to ask Mr. Tkachenko, you mentioned the, so to say, arbiters who take some symbolic payments, charge very little money, but they make some out-of-court settlements. You referred to some other European countries. Yes, it's in the other European countries, these are either governmental bodies or some non-governmental bodies, but established by some professional or business associations. When you send your complaint to them, you can even address to them the claims or complaints from the other countries. There were the cases, for example, when Romanian citizens were lodging complaints to the French authorities, and there was proper reaction on their part, and they thus avoided the costs of court proceedings. The idea is that there could be the institutions that can operate within fairly strict time limits and help the consumers resolve their claims. And compensations are paid, for example, from the funds that are created by some business associations. In case of minor sums of money, if the price of the goods or services was substantial, that could be paid, or its payment could be enforced via the court of law. For example, in the Ukrainian context, if you have defective goods for, let's say, 400 hryvnias, you would not go to court because the court proceedings would cost you more than 400 hryvnias. What we do is as I told you, we placed this standard, or rather these bodies usually they publish the standard complaint forms that the public can download from their websites. And I didn't mention that in my presentation, but they also have the collective disputes resolution mechanism, and I hope that it could also help us in our situation in Ukraine. For example, these illicit petrol stations. If a person bought some petrol for, let's say, 600 hryvnias, and then that person discovered that the petrol station was operating illegally, he or she would not most probably lodge a complaint and incur these expenses in the court. The advantage of these out-of-court settlement institutions is that you could economize, so to say, not to spend your money in terms, even in the cases of small, small purchases. Certainly, if larger sums of money are involved, then the businesses that could be illicit businesses, when they are sanctioned, when they are punished, especially fined, these fines would make them start thinking about the legal ways of reorganizing their operation in a legal way. Sergei Savchenko, Vremya newspaper from Kharkov. Could it be realistic in Ukraine to implement the practices that you have described, and how soon could it be done here in Ukraine? Well, I hope that if the EU member countries manage to establish similar practices, we can do that here in Ukraine. For example, the receipts were mentioned. If you see on your receipt the testing, operation, inscription or something like that, it means that the cash register is merely being tested. It's not operating validly and full scale, and this receipt could not subsequently be used as a document for compensation, for claiming the compensation. So this issue of receipts is important, and that option, as I told you, that option of verification of the receipts is useful in this respect. If you have verified your receipt and it appeared that it was valid, then it's much easier. But still, in Ukrainian context, it's very difficult. It's still going to be very difficult to get compensation. Because of the number of reasons that have already been described by a number of speakers. But at least if you have this receipt, you at least could raise this issue even in a month's time or 2 months' time. You can lodge your complaint to some governmental bodies. And for the business associations, as we have heard, who monitor the situation of illicit or illegal services or trade in goods, if you bring your situation to their attention, then the resolution issue could be much simpler. For example, if it's a legally operating business and they receive 100 or 200 complaints, for them it would be very strong stimulus to react to any erroneous, so to say, situation. So my conclusion is that it's not easy to implement these things, checks and balances, so to say, in Ukraine, but it could be done, provided that the law also provides for such options. Because the existing laws are merely declarative, as we have heard, and it's difficult using these laws in order to implement the real protections of your consumer rights. Oksana Kovalenko, Chuguev. I have a question to Mr. Kobelkov. You mentioned the fact that the NGOs can share their information with you, their complaints, for example, could be lodged with your service. My question is, can you and how can you help, in case you can help the NGOs in resolving these issues? For example, there was a case in our area when there was the illegal dumping of industrial and other types of waste. If we detected a allegedly waste processing enterprise that works only during the nights, and we have, and there are some other indications that they are not operating legally, they do not have a proper license, what could be done in order to cope with such violation? Well, as I emphasized, we have the whole, in our website, there is the whole chapter, so to say, dedicated to the findings of the NGOs on their testing of different goods, their safety and quality. If we can see that your findings are confirmed by some laboratory or by some validation bodies, we will certainly publish your information. As far as the other issues that are not covered by the law on the protection of consumer rights are concerned, I cannot comment on all the types of violations. But for example, if the environmental violations of environmental law, then I know that there could be some government bodies under the Ministry of Health that could help, and some sanitary and epidemiological control bodies could be helpful, could be involved, and could render some help. And as Mr. Oleg mentioned, the more you write to the larger number of government agencies, the better are your chances to get some reaction. And you should know that according to the law on the addresses by the citizens, any complaint should be the reaction by the government should be provided within 5 days to any complaint that it received. There is also the law on the state monitoring and oversight. Article 6 says that the complaints from the NGOs are not subject to the reaction of by the government bodies. They only react to the complaints from the persons, from the individuals, physical persons, so to say. That's why we abandoned our cooperation with the Disputable, because they, by the law, cannot react to the complaints or claims by the NGOs. Well, if just one clarification: if your complaint as an NGO is accompanied by at least one complaint from a physical person, then our service can perfectly well review and react to your complaint. There was a real case that I referred to, and it was only yesterday that we received a letter informing us that that illicit waste processing plant was shut down, but it's been more than a year since our first complaint, and I was wondering why it has taken so long to take down that illicit enterprise. Well, I can tell you that, for example, according to the law of Ukraine on the prohibition of smoking in public places, not only cigarettes and other tobacco products are prohibited for smoking in public establishments, but also the so-called kalyans, or the hookahs. And 5 years, for the last 5 years, there have been a number of complaints from the people who live in the blocks of flats in the ground floors of which these hookah smoking establishments and or restaurants are working, and people were complaining for years, but nothing was done in order to stop this violation of the law on the smoking in public places. What were the reasons for that long time? Well, because of different government bodies were involved in reacting to them, and so the procedures were not clear, and we understand that our Держпродспоживслужба is the government body that is, so to say, the first line in terms of reacting to the complaints, but in many cases we cannot react by the law. It's other governmental bodies as well, and our approach is also not to try to somehow, throttle small and medium-sized businesses. Any more questions? My answer to your question is that you should certainly make an individual complaint as an individual, as a citizen. And my other advice is that sometimes you would be pleasantly surprised if you publish your information on Facebook, how more rapid a reaction to your complaint is or could be from the government bodies. We, in our work, we collect and share our information with the other business associations, and we are trying both to initiate the reactions to the complaints and also to set an example and to explain the procedures of how these violations could be fought against. The very idea of our activity, I have explained it to you, and we are open to cooperation with you. My last name, Mr. Zubchinok says, is Zubchinok, because sometimes the journalists make mistakes in writing my last name. My question is related to the cost of your electronic, so to say, effort, that map you've mentioned. How much did it cost, and could it be used by other businesses or business associations, and could the social media be used? For example, also, could the monitoring of the quality of services be added to this service? For example, we saw that it's very efficient and effective in terms of illicit petrol stations, but can it be also used in the other sectors of economy? Well, in truth, this is a rather simple system. The options, some additional options, could be added later on. Our task was to, first of all, produce this instrument that could be used by the public. And if it appears that in your sector, for example, the public is not interested, the government bodies do not react, then you probably do not need to invest any more money in it. But in our case, this platform has not been costly. The applications have been developed by the other commercial companies, our company members. I'm not going to give you the details on exact prices of this work, but you can see that using the Google Maps, for example, and other software, it's not going to be very costly, and it's not costly and could be transferred fairly easily to the other colleagues. If you add the rating system there, for example, on the feedback and so on, you could clearly see the effectiveness of your work. In our case, a map of these illicit petrol stations could be, it's being completed, it's being filled in and updated all the time, and so we hope that we will have the complete map, so to say, with the complete information quite soon. Again, Healthy Ukraine. My question is to Mr. Kobelkov. You mentioned the fact that you examine the food products together with the NGOs, and you are using, you've been using the laboratories, testing laboratories. Would it be possible if an organization, an NGO interested in the quality of dairy products turned to you, would it get any assistance from you? Well, first of all, it might be a surprise to you if I say that the law on the protection of consumer rights has not been covering for the last 2 years on the safety of food products. It's practically a unique situation in the world, but that's how it is, the way it is in Ukraine now. And so we hope that this new bill that I mentioned would return to our service the authority to monitor the food product safety. We have the whole department that covers food safety, but it has in its work is guided by the other laws, not the law on the protection of consumer rights. But according to my information, a lot of NGOs they do similar information. They do similar work on testing the safety of food products. You need to turn to our service to file a letter, to send an address or a letter, and generally speaking, as of now, our work today is more focused on supporting, on sustaining and promoting the findings of the NGOs and publicizing this, their information. In our site, as I told you, there is a part that is related under a separate heading. It's dedicated to the results of the tests of the safety of food products. But as I told you, paradoxically, our authority is now not extended to the checks of the food product safety. I have a remark or comment, probably. You all mentioned to different extents about the rights of consumers, and I think it was only Mr. Tsilvick who mentioned the real protection, the ways of and procedures of protecting the consumer rights. My question is, what would be the real mechanism of protecting the rights of consumers if we speak about out-of-court options? You mentioned 40%. What is the main principle of your activities in protecting consumer rights? Well, as any government agency, our activity is defined by Article 19 of the Constitution that establishes that the authority of any government body is limited to its authorities and functions determined by the law. So by the law, our function now is to conduct the inspections, and upon the results of these inspections, we can exercise a number of instruments, including the fines, for example, or even the termination of the activities of enterprises. So for us, the top priority now, according to the law, is to conduct inspections. The number of instruments is really broad. We can put fines on both the enterprises themselves and on their owners and top managers, and the whole array of other instruments to produce impact on a business's activity. Let me quote the law. It's 8 pages. Of the report. 6,300 enterprises were checked in 2018. In 45% of cases, there were violations of law in their activities. The main violations were the lack of access to correct information on their activities. This information, as established by the law, should provide the opportunities to a consumer for informed choice of goods and services. So it's not the coercion of any kind, but just the choice. About 7%, in the 7% of cases, it was the sales of goods, the terms of use of which had expired. Safety of goods and services inspected, and the costs recovered were about 80 million hryvnias, including the low quality food products, 22 million hryvnias. 36 inspections resulted in the transfer of the materials and findings to the out-of-court settlement bodies. Let me finish. The inspections resulted in administrative responsibility of 1,700 people. 265,000 hryvnias were paid in compensations, and the fines amounted to almost 14 million hryvnias. Approximately 21,000 complaints from the citizens were reviewed last year, and 45% of those claims and complaints were related to the quality of non-food products. Around 40% the quality regarded the quality of goods, mostly the local utility bodies. Also, the internet commerce establishments were reviewed. 41% of the claims resulted in positive resolution. And would you like to share this statistics with us? What is the percentage of complaints in this area of e-commerce? How much were resolved positively, or have been resolved positively? Well, the statistics that we have by different year by year, but I can describe the trends. Why do we try to actively involve the mass media with respect to those wrongdoings in the e-commerce sector? Let me again give you some statistical data. The trend is, though, in 2016, the number of claims and complaints was 3.2%. In 2017, 4.5%. In 2018, 6.3%. And this year so far, 6.5% out of the total number of complaints and claims. Therefore, in 2017, well, you quoted a figure of compensation to the consumers. 7 million hryvnias were repaid, were compensated. I couldn't understand from your explanation how much fines were channeled to the national budget. Was it 270,000? Well, they were divided into administrative fines and the other types. But what was, for example, the reaction of the businesses on this idea of elimination of this book or log of complaints that each commercial establishment should have had previously? But it was eliminated in order, allegedly, to alleviate, so to say, the burden on businesses, especially commercial establishments. Well, as I know, the protection of consumer rights is not now a priority of Держспоживслужба. Information, distribution, awareness raising, and so on. I remember that there was previously there was around 120 million hryvnias allocated for the veterinary inspections done by the inspectors of your service, and the other sums of money for different other types of inspections. But as consumer expenses amount to almost 86% last year in the total amount of GDP, which is 30% larger than in the medium for West European countries, does that mean that an individual entrepreneur is inaccessible to your service? So maybe if the entrepreneurs do not have to have these books of complaints, maybe that could pay some share of their profits in order to compensate the complaints from the consumers. Well, you are right that this book of complaints was eliminated by the decision of the government. But for your information, our Держспоживслужба, our service for food safety, was practically the only government body that objected to that protested that decision. And because we view this book as a primary source or a primary option for a reaction from the consumer, when a consumer can register the fact of refusal of a commercial establishment to react to his or her complaint if, for example, a product or service was defective or some other rights of consumers were violated. But I think that this book is not the only option for the protection of consumer rights. We have the other options, and we have the other instruments. First of all, we need to have this fact of the refusal for compensation or any other redress of consumers' complaints by an enterprise, a commercial enterprise, or any other. It should be fixed somehow. So write your complaints to us. Having this information about these refusals, we could somehow react. Well, this Ministry of Economic Development's initiative to eliminate that book, it was the idea of the ministry, but if the existence of these books were also regulated and the complaints there should have been filed according to certain standards. If these standards were violated, there could be no reaction from the ministry and its bodies. But I think that the other mechanisms were introduced, and this book, as it was important for some citizens and for some situations, it could be effective. It was not adequate according to the provisions of the law on the protection of consumer rights. If we speak about the businesses that are either fraudulent or just negligent, you should just stop your dealings with them. if even your complaint is successful and that the business establishment is fined or something, it will be shut down and you will not get your compensation from it. And the information campaign that you mentioned was, for example, it included, for example, the notes for a consumer, in which or through which we advise the consumers on whom to address, which authority, which government body, and what should be the procedures for that.
A remark about your proposal to create a fund that would compensate the expenses of customers. This idea is good, but it should be carefully implemented because in some instances good sellers would compensate to unfair customers, and first association should be created, and the members of association should create such funds. And if you are a member of the association, you should adhere to some standards, because if you oblige everyone, it can lead to the situation then some fair would compensate those who are unfair. So we do not have proper laws. That's why this issue is not on the agenda, and I don't believe that they will create such funds to compensate to unfair or shadow entities. So thank you very much. Thank you, dear journalists. We should be calm, and we have this discussion, and we have issues that need to be resolved, and we are going to speak, and we will write about it, because we protect our own rights, first of all. Thank you very much for this active discussion. Thank you for your questions.